Demand letters and the Deceptive Trade Practices Act. Hi, this is Consumer Protection Attorney Bill Clanton. I've helped hundreds of consumers deal with debt collection harassment, inaccurate credit reporting, and other consumer-related matters. And this is one of those other consumer-related matter issues. It comes up a lot. It's the Deceptive Trade Practices Act and one of the statutory requirements of the Deceptive Trade Practices Act. Now, a little bit of background on the DTPA. The DTPA is a Texas law. Many other states have similar laws. They're generally referred to as UDAP, Unfair Deceptive Acts and Practices, UDAP laws. In Texas, our UDAP law is known as the DTPA, and it protects consumers from misrepresentations by merchants. There's a whole laundry list, like 25, 24, 25. It's always growing. I think maybe up to 28 by now. Different violations, things that are absolute violations. It's also a violation for a breach of warranty or breach of any number of things. Breach of warranty and then the enumerated list are two of the most common. And there's a number of statutes that they call tie-in statutes, that if you violate another statute, then it ties into the DTPA and you can get DTPA relief through the tie-in statute. Okay, that's probably more than you want to know about the DTPA if you're watching a DTPA demand letter video. Now, one of the things that's required by the DTPA is a demand letter. The demand letter has to be sent 60 days before you file a lawsuit. The demand letter should set out all the facts giving rise to your case under the DTPA and make a monetary demand under the DTPA. You ask the defendant for the same award that you'd be seeking from a court. It's the first step in preparing for your DTPA case. It's the first official step. Of course, you need to find a lawyer, give them all the information and all the documents that prove your case. But the first official step towards bringing a DTPA case is sending the demand letter. Now, the demand letter ensures the defendant receives the notice and has the opportunity to settle the case without litigation, or they can request additional information. So you send the DTPA letter. It's best to send it certified mail. You know they've received it. The clock is ticking. They know the clock is ticking. They better find a lawyer and they better respond to this letter. Now they can cut their losses by fixing the situation. That's what 60 days is for, to settle, pay you money damages, fix the issue that is the reason for the letter. That's their opportunity to fix this, because once a lawsuit's filed, the stakes are much higher. They have to pay their fees. Under the DTPA, they have to pay your lawyer's fees. So it can get very expensive to litigate a DTPA case for a defendant. And of course, it gives a 60-day notice before filing a lawsuit. So I hope you understand the reason for the 60-day notice under the Texas Deceptive Trade Practices Act and how it helps resolve cases. Because if you've got a plain case, if you've got an easy case, easy to prove case against somebody for doing you wrong, and you can bring it under the DTPA, the letter should fix it. It'll go a long ways to helping them understand how they did you wrong. If you feel like you've been wronged by a merchant, car dealer, anybody else, and you may have a case under the DTPA, give us a call. We'd like to talk to you and see if we can put together the facts and the law to bring a case against the DTPA, against somebody for violating the DTPA. Please consider subscribing to my channel, and thank you for watching.